Good afternoon. My name is Barton Morris. This is Jennifer Domain. We're the lawyers at the Cannabis Legal Group, and you're watching Cannabis Live on our Facebook channel. Today and every week, we're going to talk about the business that affects the cannabis industry in the state of Michigan and around the country. We do this from our offices here in Royal Oak at the Cannabis Legal Group, and we hope that you join us every week. Today, we're doing this show at 4 o'clock, and I think in the future we'll be doing it every week at 4 p.m. And hopefully more people will be able to join us. But if you can't join us at 4 o'clock, then it'll always be available on our Facebook channel and on our YouTube channel at cannabislegalgroup.com. Today, we are going to discuss operating agreements. An operating agreement is an agreement that generally defines the rights and responsibilities and demonstrates the management of a LLC or a corporation that is generally set up for marijuana-related businesses. There are two general types of corporations that we use. There are LLCs, or a limited liability corporation, or the other type is a shareholder corporation or a C Corp. This week we're going to talk about LLCs, and I think perhaps next week we're going to talk about stock corporations or general C corporations. So this week we're going to talk about LLCs, and we have to have one for each of our companies. And it's actually fascinating about how many of them aren't done properly. So we're going to get to that. But first, we're going to talk about our week's news.
So this week's news really revolves around the topic of temporary operators. You've heard us talk about this over and over and over as temporary operations continues to evolve within the state. The temporary operators right now are provisioning centers that haven't obtained a full license and are currently operating under Attestation E. As you may recall, the State Department had issued an advisory bulletin that they were going to be shut down as of the end of last month. However, there was a stay at the the Court of Claims level, indicating that they were to remain open pending the full review of whether or not there was enough licensed provisioning centers in the state to support the demand of the patients. The Court of Claims is continuing to review this, and they have another hearing scheduled for April 18th, which is next Thursday. However, the Michigan legislature has also introduced House Bill 4440 to address this issue, where, if passed, temporary operations would be advised to shut down by June 1st. If a temporary operator was to continue to stay open after June 1st, not only could they be penalized with fines, but they would be unable to file an application to get a fully licensed state license for any of their applications for 1 year. So effectively, this allows the department to have a little bit more control, not only to have a monetary penalty, but also to restrict how long they would have to wait, or enforce a restriction on how long they would have to wait before they could issue a new application. So this is something that is done on the legislative side. We are currently having a review on the Court of Claims side. So we have a couple different avenues going right now when it comes to temporary operations, but this is going to be a constantly evolving topic.
So, excuse me. While these businesses can remain open, at least for now, does that mean that they're able to still continue to obtain their product from caregivers?
Technically, it does. That's my understanding of it. The order from the Court of Claims did not specify whether or not they were going to restrict that or take up an issue with that portion of it. However, if they have an issue with the entire advisory bulletin related to temporary operators, it's our understanding that at this current point in time, temporary operators can continue to take product from caregivers and continue in their normal fashion.
This is interesting because I know that, first of all, caregivers, they are still proliferating and providing these activities or engaging in activities where they believe that they're going to be able to continue to provide marijuana to dispensaries and to growers. And I know that there's some confusion about that, especially because they're not really protected by this.
Right. Caregivers are, as we've talked about before, not protected. They are working under the MMMA, which just says that caregivers are supposed to be doing this for the benefit of their patients. They shouldn't be getting monetary gain from this enterprise at all. But we have a scenario where the state is saying to facilities, we will allow you to accept that product in exchange for funds. We just don't have an actual protection in place for the caregivers. There was an advisory bulletin that was issued saying that caregivers or processors and growers could obtain product from caregivers. But again, this really kind of stems back to the fact that we don't have anything from or related to the MMMA giving that protection to caregivers as well.
This is something that a lot of caregivers have to understand. I think that a lot of caregivers right now think that they are permitted to grow their 72 plants, but also cultivate as much as necessary to be able to distribute to the licensed entities, and they're going to be protected. But that's just simply not the case. There is not going to be any like entrapment by estoppel defenses or any type of defense where they can say, well, the state allows us to do it. Well, the state doesn't allow the caregivers to do it. The state are giving that permission to the licensed or temporary operators that are seeking to get licensed, right?
Yes. I think another big point here is if you're a caregiver and you're driving all of your product to a facility and you get pulled over and you have more than 2.5 ounces on your person in the car, that's a big problem. And I can pretty much guarantee that those caregivers have more than that when they are looking to sell it to those licensed entities.
Right, 2.5 ounces per patient. So perhaps like up to a Michigan pound of 15 ounces.
Right.
Yeah, and I think the one other thing I wanted to mention is the fact that there are licensed businesses that have spent a lot of money in getting licensed, and they are competing with those that aren't licensed at all. And the caregivers are in the mix as well. There's a lot of complaint about that, and I think rightfully so. If a licensed operator, dispensary, or even grower is doing everything they're supposed to do, have gotten licensed, and now they're supposed to be the benefactor of this business, yet there still continues to be an extension of temporary operators and caregivers interceding. That's something that more and more the industry is not tolerating, and I certainly hear their complaints.
And it's completely reasonable, but again, this is going to be one of those like continually evolving conversations.
Right.
But I think it is a good sign that not only we're addressing this with the Department and Court of Claims, but also from the legislative front as well.
Okay, any other news?
No, I think that pretty much covers it, but again, we'll be coming back to you every week with updates on these developments.
Okay, thank you.
All right.
Now let's talk about operating agreements, and specifically limited liability corporations. The operating agreements are the documents necessary for each of these corporations for a variety of different reasons. And they can, if drafted properly, they will clear up a lot of difficulty in the operation of the business. But if not, there could be the potential for a lot of problems. So we're going to talk about that. Can you talk about how an LLC is set up in general with respect to its members?
Sure. So in order to set up an LLC, first you have to file the Articles of Organization with the state. This is just a document that you have to file on LARA's website indicating the name and if there's any special provisions regarding your LLC. Once it's accepted by the state, then you have a legal LLC that is formed and ready to be operated with. However, you should, and sometimes you will need to have an operating agreement. If you have multiple members or owners in a business, you're going to have an operating agreement, which is really going to dictate how you do everything. It's going to dictate how much ownership interest people have. It's going to dictate how you bring in new members, how members leave, how you can distribute funds, and what happens with voting and how the whole business decision route is made. So really, an operating agreement is kind of like your playbook. everything you need to know about your business is going to be in there, including specifying who your owners are and how much ownership interest they have.
That operating agreement, that's akin to perhaps the bylaws for a regular shareholder corporation, correct?
Absolutely. It's going to have everything in there.
And there are a couple different ways that a LLC can be created with respect to its management, and that has to be identified in the articles of organization. What exactly has to be identified? So
if you want to have a manager or a group of individuals who are acting almost like a board of directors for a corporation, you can elect to have management in your articles of organization and in your operating agreement, showing that you will be basically divvying up the responsibilities between just basic members and the people having the majority of the authority to act on behalf of the company. All right, so what's the most normal manner of operation or organization for an LLC? If you are just creating an LLC and you do not elect to have managers, then if you and I create an LLC, we're both members. And we can decide whether or not we're 50-50 members. We can decide whether you're 90 and I'm 10. But the default is that we are just members and we can both act on behalf of the company together or separately as long as we're representing the company. We both have a fiduciary duty to that company. Now, if we elect to have you as the manager and it's in the articles of organization and it's in the operating agreement, it'll say what you can do, what you can't do, when you need to have a vote with all of the members, but it'll kind of state explicitly what your powers are, and you will have a duty to the company and you will have to perform to that standard. Okay, so since you would like to use the example of you and I in a business, let me give you an example of a scenario which I hope never happens, but I could see it happening, but perhaps some other people, which is you and I were in a business, let's say we are growing marijuana and I am doing less of the growing, that's your expertise, and you're in there all the time, you're managing the books, you're taking care of the business, you're paying the vendors, and I'm just kind of the investor, but we're both managers, we're both members, right? Okay. But then you start kind of, paying yourself a little bit more, or you're not really disclosing to me, all of the activities that you're engaging, and perhaps even not that you would ever do this, but of course. But let's say somebody's doing that, and then they're not really operating in a manner that is contemplated amongst ourselves. That's in the operating agreement, or what we thought would be our kind of mutual understanding of how we're going to operate this business. Like, what are my rights? What can I do? So if you had an issue where you thought that you were being pushed out of the LLC, where you felt like I was kind of taking control over the business and I was basically pushing you out of every aspect of the company, there is something in the LLC Act, which is the general law regarding LLCs and how they operate. If it's not stated in the operating agreement, we refer back to that LLC Act, so it's very important. The LLC Act allows for you to go to court and say, listen, Jennifer is oppressing me, she is oppressing my interests, I have an interest in this company, and she is willfully and unfair and oppressive to my interests, and judge, I want you to fix it. I want you to tell her not to do it. I want damages. I want this sort of relief. And that's well within your rights to do, and the Act encourages that. The Act, the Limited Liability Act encourages that. Yes. It seems like it would be, that would just lead to a lot of problems though. I mean, if you're going to sue me, that's something that's good, or I'm going to sue you. Right? That's probably going to be something that may be difficult for people to. By the way, if there is some type of lawsuit like that, do you think that that's something that has to be disclosed to the Bureau of Marijuana Regulation? Because that's civil litigation? Yeah. That's interesting. Yeah, I do. Now, if we're both managers and we are managers and I'm a 90% manager and you're a 10% manager, and it's a manager decision that we have to make. You're talking about, when you say 10% and 90%, you're talking about like voting rights? I'm talking about equity, like shares. Both right now. Let's
Okay.
just for ease of understanding, I'm talking about both. So pro rata voting and equity.
Like, let's say, for instance, you put in 900,000, I put in 100,000, equals $1 million. You get 90% of the voting and the equity. I get 10%, right?
Yes.
Okay, got it. Go ahead.
So for the...
You have a lot of money.
Yes, I do. You have to have a majority approval. Now, if it's in the operating agreement that managers can have to make a decision, and we have in the operating agreement that there's going to be pro rata voting rights, then I basically get to call the shots on everything that happens with that LLC because I have
might as well not even have a vote.
Exactly. So that's why you want to be careful about how you're drafting your operating agreements. Because if you don't have that, and we're just members, we're not choosing to be managers or have that additional level in the operating agreement, then you've got to vote, I've got to vote, and if we have somebody else who's a member, they also get a vote. We're all 33.33%.
Regardless of the equity share.
Right? Then, so voting, we would just need to have that majority. So when we're thinking about how to draft an operating agreement, we really want to make sure that we understand who's going to be in control, how are we going to do this, and what's going to happen when you have a dispute. When people are drafting an operating agreement, they are in this honeymoon stage where they think that this business is going to just become the next Apple or Microsoft and take off, and that's wonderful. But what if it doesn't happen? What if there's some growing pains and we start to have
There
fights?
will be growing pains.
There's going to be
we should, and that's the whole point, right? I mean,
Right.
that's what we do is we try to forecast those growing pains or try to identify the issues that are almost always going to come up at some point, right? And we can talk about those, but I apologize. Go ahead.
That's okay. So basically what I was just going to say is an operating agreement, when you're talking about what you want in your operating agreement, it's almost akin to figuring out what you want in your will. These are things you don't really want to talk about. You don't want to talk about how you're going to resolve these big issues or how things are going to work out if your business fails, but you need to think about those things before you get there. This way, if there's an issue that arises, you can just look at that document and it says it right there. Because if you don't think about it and it's not in that document, or your document wasn't drafted right, then it reverts back to whatever the law says, and that may or may not be what you want. So that's my soapbox opinion.
Those are all very good opinions and advice. Now, what happens if there's some members that are perhaps operating independently amongst themselves on behalf of the corporation without the corporation or without the other members' consent? So let's say, for instance, I'm a member and I decide that I'm going to contractually obligate our company to another vendor. Or we're only going to sell our cannabis to this particular dispensary, and I enter into a contract to do so, but I didn't tell you guys about it. What can be done?
Well, first of all, I would ask why you're doing that without having a vote amongst all of the members
what
of
if
the managers.
I'm doing it because the guy that owns the dispensary is like my best friend from high school, and I'm really getting a portion of that, right? He's under the table giving me a little bit back. We're paying $1,500 a pound, but he's actually giving me like $300 back.
Well, first, if you're a manager, I would say you're breaching your fiduciary duty to the LLC. You should be working with the LLC, trying to find a vendor or a source for your contractual relationships that is in the best interest of the company rather than what's best for your pocketbook.
Yeah.
However, if you're entering into an agreement and it's not approved by the LLC, then the LLC Act again says that you can end up binding the LLC to your decision unless that other person, that best friend of yours, knew or should have known, has actual knowledge that you lacked that authority. So if you put yourself out there, I totally have this authority and I can do this, and so just sign this and we're fine. If they believe it and
it's a legal contract.
It's a legal contract, and so the LLC is bound to it. Now the LLC can come after you for any damages that might have occurred due to your breach of your fiduciary duty, but you could technically bind the LLC through your unilateral action. So it is kind of tricky. Now your friend, if he has reason to think that maybe Barton's stretching it a little bit, I know there's other people in this company, he could theoretically ask to see the articles to see if you have that authority.
Who? The friend?
The friend.
He can look at the
articles of organization.
All right, well that's online, right?
That's online, so he could pull that if he wanted to. I mean, how many people are really gonna do this? I'm not sure, but it is something that could happen. So basically, you can still bind the LLC and there would just be legal action, probably.
So it's super important probably to really define the obligations of each of these members or member managers to ensure that they're not outside of their authority. Like for instance, if I did contract the company and I didn't have the authority to do that, perhaps that's something that's left to our manager that has that like, what do they call it, purchasing manager or something like that. That's the one that, or the vendor, the sales manager, and I'm doing something outside of that, and that's something that perhaps can be certainly the dispensary is still an enforceable contract, and I can bind them to it, but the other members can do something about that kind of in-house and perhaps in court.
Exactly.
Yeah, it's crazy. That's why lawyers are always going to be in business.
Yes.
Okay, so I got another scenario here with regard to distributions, right? And like this to me is, there's a lot, people don't even think about these things when they enter into these contracts, especially when they're getting licenses and it takes so long from the time that they write this operating agreement until the time it could be years later before they're actually in a position to provide distributions to its members. Now, what if there's a disagreement about how much or what type of distributions are appropriate?
So the interesting thing about the LLC Act is members actually don't have a right to distributions unless it's stated in the operating agreement. So you can't just say, hey, it's been a long time and we have a lot of net profits this quarter, or we did really well this past year, so give me my money. I want a chunk of those net profits. You don't have a right to that, not unless it's in that operating agreement, which is why it's so important to think about these things ahead of time. Now, if the operating agreement explicitly permits distributions, then it should say things like how often they should be given, or if it's in the discretion and vote of the members, whether they're in equal shares to membership or if it's pro rata per their membership interest. So all of these things will hopefully be in the operating agreement. Otherwise, you just don't get them.
That's crazy. So you're saying that if they're not illustrated in the operating agreement, then perhaps the company then just continues to accumulate capital and funds and perhaps can spend it in any manner that they want, even through like salaries, right? Like they can give themselves salaries, but as far as distributions of net profit,
exactly,
that needs to be illustrated in the operating agreement.
Right.
And that's something that can be enforced by members. Perhaps they amend the operating agreement or their articles and then call for them, but that's something that's going to have to be dealt with later. Right.
That's something that if the members decide later that, hey, we actually don't have a right to operating distributions, but we all want a chunk of that right now, you can have a meeting, you can have a vote with all of the members and say, we're going to amend these articles of organization and the operating agreement, and we're going to allow for operating distributions because we want our money, and you can do that. Just keep in mind that distributions are treated differently than income depending on how that LLC chooses to be taxed. I'm not going to get into the whole tax world right now, but LLCs can either be taxed as a flow-through entity, meaning that distributions made from the LLC go straight to the members and they're taxed at the member level, or they can be taxed as if it's a corporation. But either way, you can have huge tax ramifications and pay a significant amount of money in tax on those distributions. So it may be worth talking to a CPA about what those tax liabilities are going to look like before you suddenly decide you really want these distributions.
Okay, I think I have one more. Well, I have lots more like scenarios, but I think we'll just deal with one more. And we talked about taxable scenarios and the appropriate tax structure for perhaps marijuana businesses. I think I was just talking to a client about this recently. That's why I'm thinking about it. And some people think an LLC is not an appropriate tax structure because of 280E.
Okay.
What do you think about that?
I would disagree with that for a couple of different reasons. First, 280E is going to apply to pretty much every business entity. That's a federal Internal Revenue Code provision. That's not, hey, you're a corporation, so this applies to you, or hey, you're a limited liability company, so this applies to you. That's just federal income tax, full stop. So that's going to apply to any business entity. So it really doesn't matter. In regards to why I like an LLC, it's more flexible. You can, it's cheaper and faster to set up, and generally you can just kind of create different avenues for yourself and how you function. You can create it to look very similar to a corporation, but legally it's different. However, you can file Form 8832 with the Internal Revenue Internal Revenue Service and say, I'm an LLC. At the time you do your taxes, right? Right. And you can say, I'm an LLC, but I actually want to be taxed as a C corporation. And I think that that gives you it'll give you an added layer of tax. It's the double tax. But generally, if an IRS agent is auditing you, then it stops at that corporate or business entity level.
I mean, liability will stop at the corporate level.
Liability and generally like the audit process. They're not going to continue to audit and flow through to your personal accounts.
All right.
So more protection.
So yeah, and that's something that I think a lot of people overlook. It's something that we've discussed with our CPA that we have in house here, Simon. Is this election to be treated as a C corp at the time that we file our taxes? I personally think that 280E is going to be dealt with in our Congress in 2019, and by the time our operators are filing taxes, either for tax year 2019, or they might even not even be in business and making money until 2020, which means they're not filing until 2021. It may not be an issue. I think this is something. This is I think the number 2 issue that needs to be resolved in Congress. The first is banking, which is going to be resolved. We've seen some movement in that, and the second was the IRS code 280E. So. I know that there's some movement on that that we can expect. Okay, so we're going to wrap that up. I think next week we are going to talk about shareholder corporations, because there is a lot more versatility that we can create with respect to C corporations. Then there's some companies that it is more suitable for, and certainly a lot more complicated and much more exciting that I'm sure that Jennifer will make it next week, because she's good at that. So. For Jennifer and Barton, thank you for watching, and we invite you to our YouTube channel and our Facebook channels, where you can see our past shows about hopefully whatever you might be interested in, and make sure you let us know what your questions are or any issues that you want to talk about or topics you want to talk about in future shows, and then we'll happy to talk about them, because that's what we love to talk about. All right, thank you very much.
Thank you.